And welcome back to the Wellness Paradox podcast. I'm so grateful that you can join us on this journey towards greater human flourishing. As always, I'm your host, Michael Stack, an exercise physiologist by training and a health educator and a health entrepreneur by trade. And I'm fascinated by a phenomena I call the wellness paradox. This paradox, as I view it, is the trust, interaction, and communication gap that exists between fitness professionals and our medical community. This podcast is all about closing off that gap by disseminating the latest, most evidence-based, and most engaging information in the health sciences. And to do that, in episode 111, we're joined by Hasson Barnes. Hasson is an attorney based in Baltimore, Maryland, and this is going to be a conversation around limiting legal liability for fitness professionals. Now, fair warning, this isn't an exciting or a fun conversation. Rarely are conversations with lawyers exciting or fun. The goal of this conversation is to be proactive, to understand the things that you can do as a fitness professional to limit your legal liability and exposure. And as we'll touch on in this episode, working with a higher risk population medically, like a number of our professionals and listeners do, even amplifies the concerns around liability that we're going to talk about in this discussion that much more. So I hope there's a lot of information in this conversation that you can use to limit legal liability in your practice as a fitness and exercise professional. Any information we'd like to share with you from today's episode can be found on the show notes page. That's by going to wellnessparadoxpod.com/episode 111. Please enjoy this conversation with Hasson Barnes. Today, we're delighted to be joined by Hasson Barnes. Hasson, thank you so much for joining us.
Thank you very much. I appreciate it. Glad to be here.
So I'm really excited to have this discussion because we're going to talk about limiting liability for fitness professionals. And I feel like most fitness professionals don't start thinking about this until it's too late and they have a liability issue. So hopefully this conversation allows our listeners to be a little bit more proactive about how they can mitigate liability issues in what they do. And certainly in our very litigious society, that's an important consideration. But before we dive into the discussion, just give us a little bit more of an idea of your background for some context.
Certainly. Hasson Barnes. I'm an attorney located in Baltimore, Maryland. I've been practicing since 2009. So it's been quite a few years. Well, no, 2007. I have my own practice. We have a small firm here in Baltimore where we do general litigation. We do small business formation. We do litigation for small businesses. So for the issue of liability, we see it all. We see whether it's people in personal training or in general, small businesses get sued all the time. And we get involved on the back end. Once things have gone wrong, once contracts have been signed the wrong way, once liability has been established, then we get involved. And by then, sometimes it's too late. So we work with clients on the front end as well to make sure they do things the proper way. Make sure they have legal counsel in place, make sure they sign proper contracts, make sure they review contracts and they understand what it means. A lot of time we see people sign contracts because they think it means something versus what it really means. We represent clients in all stages, whether that's in litigation in court, whether it's in mediation, whether it's in arbitration, or even negotiation. We help clients form companies, whether it's LLC or corporation. We help them form for the purpose of liability limitation and for the purpose of growth. We also advise clients with their other professionals, whether it's a CPA or an accountant. We help them advise as to what needs to happen going forward and what they can do to better their business. We've been practicing in the area for some time, and we're seeing some consistencies with small businesses and small actors in terms of not thinking about liability. When you're working, you're hustling, you're trying to make it work and trying to build your brand, liability is the last thing on your mind, but it shouldn't be.
Yeah, absolutely. And that's kind of where I want to start our discussion because law is complicated. That's why, people like you and your colleagues exist to be able to help business owners handle the complexity. But let's just start with a basic definition of liability, what it means in a legal context, and then what some consequences can be when your liability exposure is great.
So liability in very layman's terms, means responsibility. It means you're responsible. When someone says you're liable, it means you're going in your pocket and you're paying money. You're responsible. Now, we know legally it could be criminal, it could be civil. Criminal is called guilt and innocence, and civil is liability. And who's responsible legally for something. And exposure in terms of how much you're liable for. So typically, if you're doing business in the fitness arena, whether you own a gym or whether you're a personal trainer, there's a certain level of liability based on the work that you do personally, right? So if you're a trainer, it could be liability for the training that you give your client. So say you're doing a workout with a client and they're doing push-ups and they tear their rotator cuff. That's not a usual injury, but it may happen. They may claim you're liable because as a professional, you didn't properly advise them. Even though we all know what a push-up is, we all know how push-ups work, but you didn't properly advise them, or you didn't check their medical history to know they probably shouldn't do push-ups. And that's actual professional liability. There's general liability as well. Say you have a shop and you have a gym and another patron puts a weight down and someone falls over it. Well, there's nothing you did personally. A third party did it, but you're liable for it. You have general liability for it because it's your shop. You're liable for what goes on in the gym. You're liable for things being misplaced. Now, it gets to be more complicated when you have a physical structure. It could be premises liability, which may change that some, but in general, liability means you're on the hook for something and you may be required to pay money and or perform a service. And the amount of liability would determine is based on the happening, right? So whether a person was injured, and keep in mind, guys, we're talking about fitness. When you do and you operate as a business, whether you're a sole proprietorship or LLC, it's more than just the work you do. They may sue your business in general for all kind of things that you wouldn't assume you'll be liable for, whether breach of contract, interference with contract, and your liability is limited or expanded by what exactly they're claiming you did wrong and what harm you may have caused.
Yeah, you used a couple terms there that I think might be important to talk about. And I know a lot of individuals that go into business don't often think about this, but you talked about sole proprietorship versus like corporation and things like that. Unpack that for a second, because I think most personal trainers think, oh, I'm just going to go into business by myself and I'll just start training. There's a liability element to that. So maybe talk about the benefits of, incorporation and how that acts to limit liability.
So we see in the space, I'm sure you see much more than I do, trainers just start working. You have the skill set, you have the licenses, you go to the park and you call people out, pay me money, I'll train you. That works until it doesn't. The reality is a sole proprietorship is what the IRS uses to do tax purposes, but it means you have no shield in liability. The only reason people form companies is to limit liability, whether it's a corporation or LLC. LLC is a limited liability company. It has liability in the name of it. The goal of an LLC is to make sure you're a separate entity from your company. And you do that for the purpose of limiting what a person can sue you for. So if I'm a trainer, I'm trainer Hasson Barnes, and I'm training people on doing a marathon. I'm a former runner in a past life. I used to love to run, don't do it much anymore. My knees are shot. I used to run. But I'm training people on running. I'm a trainer. I'm training them on long runs and short runs and sprints, and I'm doing it under my own name. If someone gets hurt, they can sue me individually, which means my bank accounts are open to them. My home is open to them. My car is open to them. My other pots of investments open to them, and they may go after and reach in and grab some to satisfy their liability. However, if Hasson Barnes did it under Training Extraordinary LLC, I'm not liable for anything. The LLC is a shield. It limits my liability. The company is liable. And guess what? If the company has no money, it has no money.
Yeah.
It's broke. You can close it down and walk away. That's the benefit of having a entity. And we talk about formation of entities all the time. And a lot of times small businesses don't want to form. Most states, you have to pay a tax every year. In Maryland, you have to pay $300 every single year to maintain your LLC or your small company. But it's worth your time and your money. It's a way to limit your liability to the world. And it's more professional. When people see that you're operating under LLC, it gives the impression to the outside world that you have your ducks in a row. When you're operating as your own name, people know very soon that you have exposure there, and they'll take advantage of it.
Yeah, again, it's not no money when you're talking about a fee and incorporating, but relative to, what's on the table if you are found liable, it is a vast savings. Let me ask another question, because it's a word that seems to circle around this. And before we dive more specifically into things, I think it's important to get a definition out there. There is the idea of, with liability, negligence, right? Like you somehow done something wrong. How does negligence apply to liability? You hear those terms get used in context pretty similarly.
General liability versus professional liability. So professional liability means you were negligent, right? Or you may be negligent, right? Someone can claim you're doing a boot camp and someone got hurt and you didn't do the boot camp properly. It was too crowded in there, or the equipment wasn't the proper equipment. You didn't have the proper distance between the parties. You didn't tell the technique the right way, right? People weren't doing proper technique. That meant you were negligent as a professional. You didn't do what's required to be done in your field. That's professional liability. General liability, you don't gotta be negligent. I mean, you can be is a bit more amorphous, right? So for general liability, the example I gave is someone fell in your shop, and you may be liable for it. And you're liable because you're the one. Prime example: say you were showing a workout to some people and to some guests or some clients, and a client was behind you, and you dropped the weight, and they walked up and hit their foot. Well, when you dropped it, you didn't see them.
Yeah.
Should you have known that was behind you? Maybe, maybe not. They may have had no reason to be behind you, but they were, and they got injured. Guess what? You're liable. And you may say, well, I wasn't negligent. They weren't paying attention. That's maybe true. You're still liable. So liability, negligence plays a part generally for professional liability, but it's all kind of ways where a savvy lawyer can find that you're liable, even though you think there's no negligence. I think people think there's a nexus between liability. People think negligence means I knew and I didn't do something the right way because I intended to. No, it means mistake, right? I may have made a mistake, and that's sufficient for finding that you're negligent. It doesn't mean gross negligence where your behavior was so over the top that we're finding you liable. It's just the idea that something wasn't done the way it should have been. And in the field of personal training, you guys know any wrong thing you do can result in injury. It doesn't. The level of your wrongdoing isn't proportionate to the level of injury a person may sustain. So you may make a very, very minor mistake or omission, and it may result in injury. And keep in mind, to that point, it could be negligence could be an actual thing you did, or it could be a thing you didn't do, right? It could be an omission.
Yeah.
If you didn't tell a person, hey, when you do push-ups because of your weight and your lack of activity, you may want to start off small and start on your knees versus doing a traditional push-up. You may say, okay, here's a push-up, and you help people as you go along. Any omission you have could be negligence. And omission could be the whole thing, or it could be a partial omission. And for you guys, if you're doing personal training, a lot of times your clients don't tell you the whole story. You don't know that whole medical workup. A couple of years ago, we had a patient client that had an issue with diabetes. And oftentimes people with diabetes get injuries in their feet, they get injuries on their hand, they get injuries with bleeding and can't stop bleeding, and didn't tell anyone. They worked out and got cut, and they would stop bleeding. The trainer had no idea they had diabetes, and the person didn't disclose it because they didn't think they had to. So when they got injured, the injury got worse because no one knew how to treat it, because no one realized, oh, you're suffering from additional condition that makes what we're doing here more risky. So that's different between for liability and negligence. Typically, it does apply when you're negligent. But again, if you have a savvy lawyer, they can find negligence in all kinds of places, in all kinds of ways, and ways you didn't assume.
I'd like to take a quick break from today's episode to tell you a little something about one of our sponsors. As all of you are well aware, addressing the wellness paradox is a lifelong passion project for me. And when you're going to go on a long journey, it's difficult to go it alone. You need to find like-minded individuals that are willing to go on that crusade with you. And that's exactly what I found at the MRF Institute. The team over at the MRF Institute creates educational content for fitness and wellness professionals who are serious about becoming a part of our healthcare continuum. Getting on the healthcare continuum is all about leveling up our skills to be looked at as that valued resource provider. The wellness paradox is certainly an avenue for you to do that, but we need many different levers to pull if we're going to get there. And the MRF Institute is definitely one of those levers. You can go to their website, mrfinstitute.com, org to find all kinds of great, informative, free informational content. And if you choose to engage with any of their paid content, they've created a coupon code specifically for Wellness Paradox listeners. You can enter in WP 2022, that's WP, and then the number 2022 to the website at checkout to receive a 15% discount on your purchase. I highly recommend you go check out mrfinstitute.org. Now back to today's episode. Yeah, which sounds kind of scary, but this is where, protecting yourself with a corporation and the right kind of infrastructure is important. So along those lines, very, very common in the health club space, in the personal training space, for there to exist liability waivers. You can go online. I mean, there's any number of liability waivers that are out there. How protective are waivers against liability? I mean, if in your example from earlier, I had my client sign that waiver that says, exercising with me can cause all kinds of bad things to happen, up to and including death, and they tear their rotator cuff when they're doing push-ups. Does that waiver limit my liability?
It may. So I would recommend everyone have a waiver. So if you're doing training, have people sign a waiver. It's the first step. But the reality is it has to be a waiver that people understand, right? If you're signing a waiver, you need to know what you're waiving, your interests and your rights to. It got to be specific enough to the trainer and or the company and also the person doing the work. Mm-hmm. General waiver doesn't always apply. And it depends on where you're in the country. Certain different states have different rules. So everyone out there, certainly I'm an attorney, but seek your own counsel when you have these conversations, because states have different rules on liability, different rules on how waivers apply, whether they apply. But the reality is a waiver should be very particular and clear, and it shouldn't be vague. Now, we say vague. What do you mean by that? Vague means a person should know with specificity and clarity what they're actually waiving. And quite often, waivers don't. They're general. It's a general statement. Oh, I'm for injury. Well, what does that mean? Emotional injury or physical injury? It don't say either one. It's too vague, right? Mm-hmm. So quite often waivers are easily beatable by counsel because they can find where it's vague. Now, vague is a legal term that lawyers use. Most people don't think things are vague. It seems very clear and straightforward to people. But you can always find a way where the language in a waiver isn't sufficient to cover a party. And yeah, I would say waivers are helpful. Always have a waiver. It's the first step in your shield. For businesses, and especially when you're in service, you want to have multiple layers of protection to keep you safe from a potential lawsuit or claim. One of the ways you do is formation of an entity. That's an LLC, it's a corporation, or some other legal entity to keep you safe and protected. Another way is a waiver, and you have a waiver to waive. So the person is on notice. Hey, you may get injured if you come here. If we're doing physical training and you exert it, it may result in you having a heart attack. It may result in you having passing out. It may result in you pulling the muscle. But the universe of what can happen to you is so broad, mm-hmm. It's kind of easily to find that the waiver is too vague. And if you're working for yourself or a third party. So if you're a trainer and you're working for a company, whose name is on the waiver? Is it yours or is it theirs? Mm-hmm. If it's theirs, then the waiver doesn't include you. If it's yours, not the company, the waiver doesn't include the company. So that's another step along the way where you can defeat a waiver. So if I'm a plaintiff counsel, and my client get injured by a personal trainer, and they do something wrong, and there's a waiver for the company they work for, I may sue them directly. Like, you operated beyond the scope of your duties. Forget about the company. You're trained. You're licensed. I'm suing you directly. You said, well, it's a waiver. Yeah, it's a waiver between the client and the company, not with you. All those things come into play, and I'm sure you guys see people sue all the time, and they have, well, I had a waiver, I had a release, and they still sue, and they still get money from you. So the waiver is another step. The third step along the way is insurance. You want to have insurance in place. Insurance can be expensive, it can be time-consuming, it can be a pain in the butt. You want to have insurance because just like forming an entity, an LLC or corporation, the insurance helps to keep you protected from any person who will make a claim against you. So in case they're able to beat your waiver and say, hey, the waiver is vague, it didn't go into detail enough, insurance will give another measure of protection against you, and it will pay your lawyer fees, right? So if someone's suing you, if they're suing you for $20,000, you may have $20,000, but you may not have money to pay for a lawyer to defend it. So the insurance was going to cover your lawyer fees and or the settlement. So if they go to the insurance carrier and say, hey, we got proof your guy was liable, they may pay out. Okay, we'll settle this. It's paid, it's done. And you're protected to whatever amount that your policy is for. Or they may say, no, what, we think your person should have known better. There was a liability waiver. They should have known we're not paying for it. We got a lawyer, we'll take care of this. That's where you want to be. You want to have counsel in place to protect you. And again, the same way there's different kind of liability, it's different kind of insurance. Yeah. You can have general liability insurance or you can have professional liability insurance. I would recommend if you're doing training, whether you own a gym, whether you're doing personal training individually, whether you're doing virtual training or in person, you want to have both insurance. General liability means things that may happen on your watch, or professional liability, things that may happen that people claim it was your fault for. And they give different protections, but they are, and the reality is they're cheaper than people think they are, right? It's cheaper to pay up front. I know a lot of times people start their own personal training businesses. They're trying to start, they're bootstrapping and money's tight. I get it. It's still worth your while to have both of those insurances in place because one claim from one person can ruin you. If you don't have insurance and you don't have an LLC, they can have your home. They can have all the assets that you have. It's better to be safe than sorry.
Yeah, absolutely. So I want to circle back around to something because I think you made a really good point. I started my career working for a place called Bally Total Fitness that doesn't exist anymore, right? You're smiling because you probably, like everyone else in America, had a membership at Bally's at one point. So I was a trainer there, and I know that all the members signed a waiver when they came in to exercise. But I'm quite certain that waiver didn't say anything about Mike Stack as a trainer. So are you suggesting in that situation that for me to cover myself from a liability perspective, it would make sense for me to also have a waiver that they sign that specifically named me as a party that they were waiving liability against?
I would suggest differently. I would suggest that one waiver covers both. So if you work for an employer, it should say Bally Total Fitness and Mike Stack.
Okay.
Any performances, any duty or whatever claim you have against Mike, you waive any claim against Mike and Bally's for these services. And that way you're covered. The reality is most companies don't do that. They give a general waiver and you guys are hung out to dry. Now, they typically will cover you. Typically, because it's a corporation will cover their people. They'll say, okay, you suing Mike, we'll take liability for it. Except if you're gross negligent, right? So negligent is just, hey, I made a mistake. Gross negligence means your behavior was so far beyond the pale that it's you should have known it'd be an injury. In those cases, quite often insurance may not cover it, which means your boss not covering it. You may be liable in that situation individually for harm to someone versus going to Bally and saying, hey, someone fell doing training, go ahead and take care of that. You may be on the hook for it.
Yeah, it's a great point. I will point out to all of our listeners, the vast majority of the professional associations that certify trainers in our industry have liability insurance that is professional that you can purchase as a part of your certification through that organization. American Council on Exercise, American College of Sport Medicine. Normally it is a couple $100 a year, which is not nothing, but certainly is far less than what a judgment could be, if something goes wrong.
Yes, everyone get insurance, get insurance, get insurance. Lawyers make money by suing people. That means they find ways around liability waivers. They find all kinds of ways around it. Ways that you may think is absurd, they still find it because they got to eat. And they will find ways around your waiver if they can. The best way is have another shield. You want multiple layers of protection. Get insurance. Your insurance covers you. It covers mistakes you may make. We all make mistakes. Some worse than others, but we all make mistakes, and a mistake can cost you a lot more money. A policy for $100 a year or $200 a year, $300 a year is well worth the expense to avoid. Think about it this way: everyone that hears this likely has car insurance. You pay much, much more for that. In the event that you get into a car crash, you may not be in a car crash for years, and guess what? You still pay every single month for car insurance just in case something happened that covers it. Well, your profession is more important than driving around in the car. This is how you make your living, take care of your family, have insurance.
Yeah. So you said something that I do want to talk about it because I think it's very interesting. There's certainly in-person training, and since COVID, virtual training has became such a hot commodity. And I think now you're seeing a lot of people do hybrid. They'll go into the gym and they'll do virtual. There's Pelotons and things like that. So how should trainers be thinking about the virtual environment differently than the in real life environment?
So I haven't seen many cases, and you're right. COVID has changed. We had virtual training before COVID.
Mm-hmm.
COVID took it to a whole nother level.
Mm-hmm.
I haven't seen many cases about virtual training. I think we'll see some pretty soon because the reality is when you're in person and you're doing training, you can see a person's form, you can see their technique, you can touch them, you can come and manipulate them the way they need to be manipulated to make sure they're safe. You know the equipment they have because you gave it to them or you see it in front of you. When you're on a screen and everyone's using dumbbells or using kettlebells, you don't know what they have, right?
Mm-hmm.
They may say it's 5 pounds, they could be wrong, it could be 15 pounds. They may say it's a Peloton. It may be a Peloton that wasn't quite made the right way. You
Mm-hmm.
have no idea what they're using. So when you're talking for safety based on equipment that you know. The person that you have in front of you may have different equipment. And the question is, if you know or should know that a person that you can't see in person, you can't touch, and you can't approximate whether or not they are able to do the same workout that you're saying the same way, it's not likely they will. It's not likely. The reason you touch people is because when you say a thing out loud, the person doesn't hear it the way you say it, and you have to tell them and show them. If you're virtually, they still aren't hearing the same way out loud. When someone says to me, Hassan, get down and get in push-up position, that means one thing to me. It may mean something different to a person who hasn't been in the gym in 15 years.
Mm-hmm.
It likely does. If you ask them, hey, are you okay? And they say yes, in person, you can tell they're clammy. You can tell they're breathing exceptionally hard. You can tell they're struggling to get off their hands and knees. On camera, you can't see that.
Mm-hmm.
So as a result, you're pushing a person, maybe having a heart attack, and you have no way of knowing. So we'll see very soon whether there's a difference in actual liability for virtual versus in person. But I would still say you still want a waiver in place. You still want them to sign a virtual waiver and have it in your file before you start doing work with that person or those people, so you have a record of, hey, we went over at least a preliminary discussion about, hey, here's some liability issues. Here's what we're doing, and you waive all claims against me for this, 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 and this. A good example of that is you guys, I'm sure out there, have seen a bunch of gyms that do for young people. They do like bounce around trampoline parks.
Mm-hmm.
They sign waivers for them all the time. You sign a waiver, and people get hurt all the time. And they sue all the time. They sue for getting hurt on a trampoline, even though they signed a waiver saying I may get hurt on a trampoline. And guess what? They won in those lawsuits. Because a waiver is good, but sometimes people don't perceive the total liability issue or the total risk. And when you're virtual, I would suggest, and I don't know whether the court has found this, I would suggest the risk for virtual training is much more than in person, just because of what you can't see and what you don't know what's going on around the person.
Yeah, I would agree. And I've yet to see anything substantive come out on that. But I think you have to be extra careful, to your point, when it's the virtual environment. So one more question before we start to bring this to a close. And this is always one of the most interesting questions to ask lawyers around things in the industry. And I've heard different opinions on this from different lawyers. This is why lawyers exist, because there are different opinions. There's this thought that the more information you take in on a client or a patient, potentially the more liable you are. So as example, if I do an extensive medical history on somebody and I get all kinds of information, if I know all of that information, it's documented, I have it. If something bad happens, then I really should have known. Whereas if it wasn't documented, maybe I shouldn't have known it. And I could use my former employer, Bally's, as an example, because they no longer exist as a company. They were pretty adamant that they didn't want written medical histories on people. So what's your perspective on that? Because there's got to be a fine line there somehow.
I don't know. So I see why lawyers give you different views. If
Yeah.
you know all the issues a person have, your response may be in many cases, I can't work with you. Right.
Yeah.
If you know the person has high blood pressure, diabetes, high cholesterol, history of heart attacks in the family, history of strokes, I don't know that I want to be the trainer trying to find a workout regime for that person to get them healthy. I would rather no, because anything you do, now you will know that the person may, and you have you're the physical fitness person, you're better positioned to know if the person gets sick, you're liable for it. I can see a judge very clearly, even if they're waiving any liability and say, hey, I'm not going to sue. I'm not going to sue Michael. I'm fine. Michael knew that I had diabetes or I had high blood pressure. He had me doing a workout where I passed out and hit my head and cracked my skull. that's going to be a hard thing. So I see why Bally's wouldn't have wanted to have all the information. If I was Bally's, I probably wouldn't want it either. Because once I can easily say, oh, we didn't know. They didn't disclose to us they had cardiovascular disease. They didn't notify us they had a heart stent. They didn't. I may not want to know that information. I would rather not know and have my people work in the way that's general than specific. Because once you know a person's personal history, you go from training the person as a general client to a very specific client with very specific needs. And it's not always clear that trainers have the training they need to handle those kind of people in that kind of way. So for me, I would say you get some information, but you don't want the person's whole psychosocial and or medical history, because at that point you're on notice. And then what are you going to do now? And the answer for most trainers is going to be, I don't know. I have no idea.
Yeah, no, it's a good point. And I've heard both sides of the issue. It seems like most lawyers fall on the side of trying to mitigate liability, and so like there's a line that most lawyers don't want you to cross. I know a lot of our fitness professionals will listen to this, say, hey, the more information I can get, the more effective I can be at working with somebody. I think what you're saying is just realize if you get that information, it's professionally incumbent upon you to act on that information, or you could definitely be on the hook from a liability perspective.
And think about it. If you're a trainer and you get trained on how to help people in all kinds of scenarios, and the person comes in saying, I have cardiovascular disease, and you said, I'm gonna help them. But how? How severe is it? You don't know. They don't know. How advanced is it? You don't know. They don't know. We train, whether it's in medical or whether it's physical fitness, in general terms, right? General people, the average person, not the person who's about to pass out having the conversation. So once you have more information, it makes you less equipped to handle them. Even though you think you are, you're still less equipped to handle them than you would otherwise be, because their medical issue is much more than you were trained for. You're trained in generality. You're not trained in this person who's about to pass out because they have cardiovascular disease, because they mean different things to different people. So unless you have a doctor or their primary care physician with you in training, that much more information may not be helpful to you. It may be a hindrance.
So the quick follow-up on that is that there is the American College of Sport Medicine has a pre-participation screening algorithm. And if you meet certain criteria, you are required to be referred to a doctor to receive medical clearance. In your opinion, if somebody was sent to a doctor, the doctor gave them medical clearance to exercise and gave you the appropriate information, signed off on that, and you have that as a professional, is the doctor then liable in that situation?
All the doctor is saying is you can go work out. They don't know the extent of the workout. They don't know how aggressive it's going to be. They don't know when things change in real time between the patient and the trainer. So they're likely not liable. All they're saying is, yeah, at this moment in time, when they've come to see me as a physician, they checked out. That's a different time than when they see you. Different time of the day, different part of the day may be in stress. They may be nervous because they're in the gym. Their heart rate may be up. All kinds of things will be different at that time than when you saw them. So they can say, hey, when they're in front of me, they checked out. That puts the trainer on notice that this is a patient or a client that may be higher risk for injury and for harm, so take more precaution. But no, if something happened, then you were on notice that this person may have an issue. Even though the doctor gave you a note saying go ahead, that's still a notice. That's still putting you a notice, because I don't need that. When I go to a trainer, you don't need that going to a trainer. The fact that a person comes to you and say, hey, I got away from my doctor, that's a red flag to you. Like, why you need that? If you have that many medical issues that you have to get a doctor involved, you're on notice that this person may have more issues than you can handle, and you may want to second guess whether you can be their trainer. And if you are, take things very, very slow, be very methodical, pay attention to everything that goes on to make sure you can help them the way they need to be helped, because they are already in a high level for risk of injury and or harm.
Yeah. So take home there is, if you are going to work with that kind of person, make sure you exercise the right caution and have all the things we talked about earlier. Have your LLC, have your insurance, use a waiver, put those things in place to mitigate your liability to the best extent possible.
And sometimes being a good trainer is what helps you. Being good at your job, paying attention to your clients, making sure the goals that you're looking for don't supersede the actual well-being. We think about physical fitness when you're a fit person one way, when you're not fit, it's seen differently. So getting them to a place where they're healthy may not be a physical fit place. It just may mean healthier than they are now. Keep that in mind when you're handling people, because again, a walk on a treadmill may not be an issue for me. Some people, it could be life or death because their physical fitness is so poor. Their physical health is so bad that may be a risky proposition. So make sure you pay attention. And for all the trainers, if you have patients or you have clients who are at risk for severe injury and illness, don't be so bold and brash to think you can handle everybody. Don't be afraid to say, "You know what? I may need somebody with more expertise than me to help you with this." Because sometimes we get in over our head. I can do this. This person is morbidly obese. I can help them. Maybe you can, maybe you can't. And you got to recognize when you are maybe over your head.
Yeah, that is an excellent point. Well, Hasson, before we let you go, I'd like to let our listeners know where they can find out more about you and the great work you're doing.
So we're located in Baltimore, Maryland. Website is www.hbarneslaw.com. You can find us there. We're online as well. We have a Facebook page. I don't even know what the page is. That's
Well, the good news is your assistant shared that with us. We'll make sure we post all that on the show notes page. And this is a great discussion, for our audience. We realize the reason that Hasson and lawyers exist is they try to mitigate risk and liability in very bad situations. So even though this may not have been the most exciting and comforting discussion, it's an important discussion to have because we need to talk about these things before they happen to prevent them from happening. So before we go, I'm going to ask you the question that I always end the podcast on. And I only think I've had one lawyer on my podcast in 110 episodes. So you're the second lawyer I've asked this question to. It has nothing to do with the topic we talked about today. The wellness paradox, as I view it, kind of the premise of the podcast, is this disconnect that exists between fitness professionals and medical professionals. From your very outsider's perspective, if you can give fitness professionals one piece of advice to close off that gap and have better relationships with medical professionals, what would it be?
That's a dynamic question. Interesting. I'll say this, and we have medical professionals for clients, for whether business clients and they open their own shops and own businesses, own practices, or for personal cases and family. Medical professionals see things on continuum different than physical professionals do, physical health professionals. Their continuum is much, much longer and broader, and they see people in all levels of physical impairment. So they recognize and they understand when a person has limited physical impairment, and it's not something that's always fixable, right? Medical professionals are very aware when a person has a certain level of unhealthiness. It's not going away. They're not going to fight them to get to a place. They give them an understanding of the world, but they're not as it's not as important for them that the person lose 150 pounds. It's more important for quality of life. That affects their overall health, their blood pressure, their cholesterol, all the other issues. How they live is affected differently. So their goal typically is live a good life versus getting to being Mr. Olympia or Mr. Ironman. So the views are different and the goals are different. They're more about health and overall health and wellness, so to speak, more so than a fitness professional who's about getting you in top physical form. And keep in mind, doctors and the medical profession is very stodgy. Just like law, it's very stodgy, it's very cold and detached. They see so much stuff all the time. Their perspective is different than yours. So if you think dealing with doctors is a pain in the ass, proper language, it probably is, because they're doctors and they think differently and they see things differently and they don't have the same considerations you do. But I will say this. I think both fitness professionals and doctors both have the same thing in mind, making sure the patient and the client had the best possible outcomes. And that if that's true, there's always middle ground for you guys to meet somewhere to make sure if you share a patient or client, you can work towards their physical fitness and their mental and physical health.
Awesome. Hasson Barnes, thank you so much for joining us on the Wellness Paradox.
Thank you. Take care, guys.
Well, I hope you enjoyed that conversation with Hasson as much as I did. If you found it insightful and informative, please share with your friends and colleagues. Those shares make a big difference for us. Any information we'd like to share with you from today's episode can be found on the show notes page. That's by going to wellnessparadoxpod.com/episode 111. Please be on the lookout for the next episode when it drops in 2 weeks. And don't forget to subscribe through your favorite podcast platform. Until we chat again next, please be well.